Welcome to the final session. I am Maimon Schwarzschild from USD School of Law. The paper is by John Stiniford from Florida on the original meaning of cruel. It struck me that Randy Barnett's tease about a story about Posner and then not telling us the story might sort of embody the original meaning of cruel. But John can tell us more about that, as can the commentator Don Drips. 10 minutes from John. Take it away.
Thanks very much. I'd like to start by apologizing first to Randy for using the word normative in this paper. Also, I suspect that some of the evidence I presented is more compact than it should be, and part of that is because this is actually my fourth article about the original meaning of the Cruel and Unusual Punishments Clause. I've got a prior article arguing that the word unusual means or originally meant contrary to long usage, sort of a common law concept, and that the clause was designed to prevent cruel innovation in punishment. I've also written an article arguing that the original meaning encompasses a proportionality principle, and finally that the original meaning includes a principle of constitutional change or development, that as usages change over time, under some circumstances, what punishments count as cruel and unusual can change as well. So here's yet another article on the Cruel and Unusual Punishments Clause. It may seem like I'm writing a lot, but I've still got like 4 words left in the clause that I haven't even touched. So I could make a career out of this. So let me just briefly, I know you've all read the paper, so I'm just going to briefly sort of describe the problem I'm trying to deal with here. It's the question of what the legal meaning, I think, of the word cruel originally was in the Cruel and Unusual Punishments Clause. And by legal meaning, I mean what were the minimum factual criteria necessary for determining that a punishment is cruel? And there are at least sort of 2 dimensions to this. It's a very the word cruel is a very evocative word with lots of sort of multiple possible meanings. But I think when it comes down to the question of how the meaning cashes out in law, there are 2 descriptive issues and 2 sort of normative, sorry Randy, issues that are relevant. And sort of the main descriptive issue is, does the word cruel only relate to the harshness of the punishment, or does it describe the intent of the punisher? That is, to show that a punishment is cruel within the meaning of the Eighth Amendment, do you only have to show that it reaches some level of harshness, or do you also have to show that there is a punisher with some kind of cruel state of mind? I call these the cruel intent versus the cruel effects reading of cruel. And then a secondary issue, but one that's quite important when we're trying to figure out how to apply the rule, is what are the reasons that the clause condemns cruel punishments, right? So if we're thinking about a punishment, if cruel means cruel effect, right, then it must mean that the punishment is harsher than can be justified according to some constitutional standard, right? So the moral or normative issue is, how does the harshness relate to the relevant constitutional standard? On the other hand, if cruel means cruel intent, then our reason may have something to do with the coarsening of public sensibilities, that we don't want to be bad people, we don't want to be cruel people, we don't want the government to be cruel, and so we condemn punishments that exhibit this sort of intent because we don't like that sort of intent. Now in recent cases, dating back really to the 70s, but much more strongly in a couple of recent lethal injection cases, some justices have argued for the cruel intent reading of cruel. In particular, Justices Thomas and Scalia have argued that a punishment can't be cruel within the meaning of the Cruel and Unusual Punishments Clause unless it's deliberately designed to inflict pain for pain's sake. And there are a number of reasons that justices have given for this reading of cruel. Justice Thomas has given some sort of textual historical arguments looking to founding era dictionaries, legal treatises, et cetera, some late 19th and early 20th century cases. And I'll talk about that, or what I make of the historical evidence, in a little bit. There are also a couple of instrumental and moral reasons that are also given for the cruel intent reading of cruel. First of all, justices like Justice Thomas and Justice Scalia doubt the competence of the judiciary to determine whether a punishment is in fact unconstitutionally harsh, right? So punishment is by its nature designed to inflict pain. How do we determine the line between pain that's permissible and pain that's unconstitutional? I think the worry is that this is a sort of irreducibly subjective question that judges just should not be trying to answer. And so to get away from this, I think the cruel intent idea is designed to sort of create a firewall, that if it doesn't appear that anyone was trying to be really mean, then we can say the punishment is not cruel and unusual, regardless of its objective harshness, right? So that's one sort of instrumental rationale. Another instrumental rationale for the cruel intent reading has to do with sorting between those effects of punishment that can be considered part of the punishment and those effects of punishment that are not appropriately considered part of punishment. So a couple of examples. If you have a botched execution, right? No one's trying to be cruel when they give you lethal injection, but if they screw up, you might endure very terrible suffering, right? Is that suffering part of your punishment or not? Or if they put you in an overcrowded, understaffed prison and you get beaten up and raped, is that part of your punishment or not? No one wanted that to happen to you. It just happened, maybe for purely bureaucratic reasons, right? So is that part of your punishment, et cetera? And so I think Justices Thomas and Scalia try to sort out this issue by saying only the effects that were designed, only the effects that were intended as part of the punishment can be considered part of the punishment, right? So there, again, cruel intent helps us sort between punishments and accidents, right? Those are the basic rationales. And then finally, in some recent lethal injection cases, they've given an implicit normative argument or moral argument where they imply that, that in a sense, we're trying to prevent to the extent that we are trying to prevent public enjoyment of punishment. There are good reasons to permit the government to do things that reduce transparency in punishment because they reduce the risk that people will enjoy it, right? So it's okay to use a paralyzing agent as part of a lethal injection protocol because that preserves the dignity, and again, that's a very loaded term in Eighth Amendment jurisprudence, the dignity of the procedure by hiding from the public the violent nature of what's going on. The fact that the paralyzing agent also increases the risk of terrible pain, and in fact undetected terrible pain, is a trade-off that they're willing to make because they see cruelty as being a function of the intent of the punisher or indeed the intent of society and not simply the effect of the punishment. Now my argument is that in fact this is not the correct reading of the word cruel as a matter of original meaning. First of all, as I point out, they give a lot of emphasis to founding era dictionaries, particularly Johnson and Webster, by noting that both dictionaries include a cruel intent reading of cruel. They don't note, it's very strange actually to me, they don't note the fact that both dictionaries actually contain two definitions, one of which is the cruel intent, one of which is the cruel effect definition. They simply ignore that. And so I don't think the dictionaries get us very far. I'm almost out of time, so I'm not getting us very far either. So let me simply say, I think if you look at the wording of the Eighth Amendment, and particularly the fact that cruel and unusual is the standard, right? So cruel and contrary to longstanding prior practice, cruel in light of long usage. That looks like it has nothing to do with anyone's intent and more to do with effect. How does this practice compare to prior practices? Not this, how does this intent compare to prior intents? Similarly, we see excessive fines, excessive bails, cruel and unusual punishments all together in a list. Nos cetera socius, I'm mispronouncing it, I'm sure. But again, we need to read these terms consistently with each other. Excessiveness has nothing to do with intent. And presumably that points us towards a cruel effect reading of cruel. And then finally, if you look at the actual usage of the term in several salient legal contexts in the late 18th and early 19th century, my argument is that there is no one who argues that the intent of the punisher is part of the minimum legal criteria for determining that a punishment is cruel and unusual. There is one case from the late 18th century where a court seems to affirmatively hold that intent is not part of the equation when we're trying to figure out whether a punishment is cruel. And this is a situation where a jury imposes a joint fine on several defendants, and that is held to be, by at least one of the judges, cruel and unusual because it creates a risk of disproportionate punishment that exceeds the risk permissible at common law, that is permissible by longstanding prior practice. What's the effect of this reading if the court were to accept it? Well, I think the effect is, number one, this reading of the clause as a whole actually brings the clause within the judicial competence, because the judges are not asked to determine whether a punishment is too harsh as an absolute matter, but rather whether it's too harsh in comparison to longstanding prior practice. This is something that judges can do. It's not a rule. It's not something you can determine with mathematical certainty, but it is something that's subject to appropriate judgment. Secondly, it helps us to sort between punishments and accidents. I'm out of time, which means I've got 2 minutes. I'll finish up. Helps us sort between punishments and accidents by looking at foreseeability rather than intent. And finally, it focuses us on the proper normative inquiry, which is not whether societal sensibilities are coarsened, but rather whether too much suffering is happening. And that means that when the government makes a move to make punishment less transparent, as it has repeatedly done over the past century or so, the burden should be on the government to show that this move does not increase the risk of excessive suffering. All right, thanks.